Hello students. I am your ACCA Law Global Tutor with Transkyle Business School. For those new, I'm Jerry and incontactable on +263 774 596 368 or through email at transkylex@gmail.com. Previously, we looked at the linkage between business, political, and legal systems. In this week, we are going to take a step further into the area of international trade. Here are our lecture objectives. By the end of this lecture, students should be able to explain the function of international treaties, conventions, and model codes. Explain the roles of international organizations such as the UN, the ICC, the WTO, the OECD, UNIDROIT, UNCITRAL, and courts in the promotion and regulation of international trade. Let's first look at the barriers to free international trade. Barriers to free trade exist to protect markets from outside competition. These include 1. Tariffs or customs duties, i.e. taxes on imported goods. The effect of a tariff is to raise the price paid for the imported goods by domestic consumers, while leaving the price paid to foreign producers the same, or even lower. The difference is transferred to the government sector. 2. Import quotas, i.e. restrictions on the quantity of a product that is allowed to be imported into the country. 3. Embargoes, i.e. total bans, that is, effectively zero quotas. 4. Hidden subsidies for exporters and domestic producers, for exports, export credit guarantees, insurance against bad debts for overseas sales, financial help, such as government grants to the aircraft or shipbuilding industry, and general state assistance. For imports, complex import regulations and documentation, or special safety standards demanded from imported goods and so on. 5. Barriers created by differences in laws, for example differences in interpretation of contracts create enforcement problems in international trade. Now, before we dig deeper, let's revisit conflict of laws. This is an important area in the context of international trade. Conflict of laws is where parties from different nations have a legal dispute, and it is necessary to determine which national law governs the validity of the legal situation. E.g., a contract is made in Zimbabwe but the contract is to be fulfilled in South Africa. The relationship between the parties breaks down and legal resolution is sought. But should this be under Zimbabwean law or South African law? This brings in the need for international treaties. International conventions, treaties, and model laws. International cooperation is necessary to ensure that solutions can be discovered when issues like the ones mentioned above occur. Should this not be the case, any solution sought might not be enforceable and the parties might be able to avoid one another. In order to address these issues, nations have negotiated agreements among themselves and passed a number of conventions and treaties that govern behavior on a global scale. States and other entities are obligated by international law to abide by UN conventions. One example of a policy that specifies which law should control the validity of international contracts is the Rome Convention of 1980. It establishes the basic rule that a written contract between parties should apply if the parties have indicated in the written contract that they desire a certain law. We call this choice of laws. The 1958 New York Convention outlined the nation's commitment to send cases to arbitration. Conventions haven't, however, always provided a perfect solution to every issue raised by conflicts of laws. Additionally, model laws from the United Nations, see below, can be incorporated by nations into their own national laws. They resolve any lingering issues and standardize methods around the globe. Role of international organizations in trade. Important bodies associated with international law include the EU, the UN, the ICC, the WTO, the COE, the OECD, and UNIDROIT. ACCA Law Global exams often require candidates to explain the role of specific organizations. For example, in June 2008, UNCITRAL and UNIDROIT. The UN, United Nations. Principal goals. Preservation of security and peace. Fostering goodwill or friendly relations among nations. Encouraging collaboration in the resolution of social, cultural, economic, and humanitarian issues, and encouragement of observance of international freedoms and human rights. The UNCITRAL, United Nations Commission on International Trade Law. One of the two organizations actively involved in creating international law is UNCITRAL, the other is the International Law Commission. UNCITRAL focuses on the development and codification of international law. It seeks to address the practical issues brought about by various countries having disparate trade laws, standardize international law in areas like e-commerce, sales of goods, and dispute resolution, and also promote international trade by introducing the Hamburg Rules, which cover the carriage of goods by sea and international bills of exchange. UNCITRAL coordinates the efforts of the several interested organizations in an effort to harmonize and unify international trade. The organization is instrumental in fostering interorganizational collaboration, expanding participation and acceptance of current international conventions, creating new international conventions, model laws, and uniform laws, and advancing strategies for guaranteeing uniformity in the interpretation and application of laws and conventions, gathering and sharing information about national laws and legal changes while collaborating closely with the UN Conference on Trade and Development, and keeping in touch and communicating with other UN entities involved in global trade. WTO, the World Trade Organization. The WTO was established in 1995 under the auspices of the General Agreement on Tariffs and Trade, GATT. It is committed to advancing global free trade in products, services, and intellectual property. To this end, it actively strives to eliminate trade barriers such as tariffs, import regulations, customs, and bureaucracies. It facilitates the formation of trade agreements and then oversees their administration afterward. It also regularly examines other countries' trade policies, helps developing countries create their own national trade policies, and supports the settlement of international trade disputes. ICC, the International Chamber of Commerce. The goal is to support global commerce by encouraging open markets, investment, and trade. It supports fair and unrestricted business competition, which boosts economic growth in both developed and developing nations, and is also proactive in combating international commercial criminal activity. It is focused on the legal frameworks that support trading activities, such as trade agreements and dispute resolution procedures. It developed what are called Incoterms, and we will be looking at these shortly. They are going to consume a large part of this lecture and are a bit technical. Students are encouraged to pause a bit, take a snack break, relax, and resume thereafter. Let's now continue. Incoterms. The term Incoterms stands for International Commercial Terms. They were produced and promoted by International Chamber of Commerce with the idea to address the main issues involved in international trade. In particular, the terms address a. The extent to which the costs of carriage are included within the contract price. B. Which party should bear the risk in the event of goods being damaged during the delivery of those goods. C. At what moment does ownership of the goods, and therefore also risk, pass. D. The extent to which customs duties are included within the contract price. E. The responsibility for customs clearance documentation. The agreed pricing of the contract will take these Incoterms into account, which define the scope of the service and the risk assumed by each contracting party. Since 2010, just two categories. Rules for use in relation to any mode/modes of transport. Rules for transport by sea or inland waterway. Any mode of transport rules may be used when either sea transport is not involved or, if it is, when sea transport is only for part of the journey. 7 rules/abbreviations apply. I. EXWX works. Minimum obligations for the seller concerning delivery of the goods. Buyer is responsible for all costs incurred in delivery from seller's premises. 2. FCA free carrier, named place. Seller completes obligations when the goods have been cleared for export and custody has been transferred to a named carrier at a specified place. 3. CIP carriage and insurance paid to. The seller is responsible for carriage and insurance up to a specified location. Thereafter, the buyer is responsible. 4. CPT carriage paid to. The seller pays the costs of delivery to a stated location. Once at that location, the buyer assumes responsibility. V. DAT delivered at terminal. Requires the seller to pay for carriage to the terminal and the costs associated up to the time the goods are unloaded at the terminal. Does not include costs of import clearance, these costs are the responsibility of the buyer. Effectively, therefore, the goods are delivered when they are unloaded at the terminal and placed at the buyer's disposal. The terminal is the named terminal in the contract at the named port or place of destination. 6. DAP delivered at place. The seller bears all costs, except import clearance costs, involved in delivering goods to the named destination, the place. This means all costs up to the point where the goods are ready to be unloaded by the buyer at the agreed destination. 7. DDP delivered duty paid. Seller completes obligations when the goods have been delivered to the buyer at a specified location in the buyer's country. Seller pays all costs of delivery to that location, including all import taxes, customs duties, and any other official charges in the importing country. Sea or inland waterway transport rules. These rules apply when goods are being transported from one port to another. For rules/abbreviations apply. FAS free alongside ship. Only applies where goods are transported by ship. Seller's responsibilities/obligations cease when the goods are placed on the quay alongside the ship. Buyer should have arranged for export formalities. FOB free on board. Buyer arranges for shipment. Seller completes obligations when goods are loaded onto the ship. Seller provides export documentation, buyer provides import documentation. CFR cost and freight. Only applicable to goods being delivered by ship. Seller pays all costs until the goods have passed the ship's rail in the export country's port. After that point, the buyer assumes responsibility. Thus the buyer arranges for marine insurance and for customs costs. CIF cost, insurance and freight. All three costs shall be the responsibility of the seller. Insurance is such that the buyer has the right to recover from the insurer. Minimum insurance cover is contract price plus 10%. Terms apply to domestic carriage of goods as well as international. Previously these rules only apply to international carriage. Goods sold whilst in transit? Only the original seller ships the goods. So subsequent purchasers now have an obligation to procure goods shipped. Buyers and sellers must cooperate in providing sufficient information to each other to make easier the import/export of the goods. Handling costs. The 2010 terms try to remove an awkward situation which used to exist under the 2000 terms. 2010 terms clearly allocate responsibility for the handling costs at the destination terminal. The Organization for Economic Cooperation and Development, OECD. This is a group of member countries. Originally made up of nations in North America and Europe, it has since grown to include nations like Japan, Australia, Mexico, and Korea. Members of it come from most of the continents. An institution created to manage post-World War II American and Canadian aid to Europe gave rise to the OECD in 1961. Its mission statement reads, "A venue to discuss, create and enhance economic and social policies." It has produced non-binding agreements, like policies for multinational corporations, as well as legally enforceable agreements, like those pertaining to bribery. In addition to its members, the OECD extends an invitation to non-member nations to ratify its accords. It also maintains ties with 70 more nations, including China, Russia, Brazil, and several African nations. International Institute for the Unification of Private Law, UNIDROIT. This autonomous, or independent, intergovernmental body conducts research on the need for, and methods for, modernizing, harmonizing, and coordinating private international law, particularly trade law. It was founded in Rome and has been in business since 1926. Only the 61 states that have ratified the UNIDROIT statute are eligible to join UNIDROIT. They represent a multitude of diverse legal, economic, and political systems as well as all 5 continents. The structure of UNIDROIT is as follows. Overseeing the day-to-day operations of UNIDROIT's work program is the Secretariat. In addition to a number of auxiliary staff members and foreign civil servants, there is a Secretary General. The policies of UNIDROIT is overseen by the Governing Council. It creates the work schedule and oversees the Secretariat's implementation of it. It is made up of the Institute President and 25 elected members, who are usually distinguished academics, judges, practitioners, and government employees. Unidroit's General Assembly is the final decision-making body. It approves the work plan, the annual budget, and the governing council election. Each member government is represented by a single person. The main goal of Unidroit is to provide contemporary, uniform, and harmonized private international law regulations. It occasionally crosses over into public international law, particularly in situations where it is challenging to set clear boundaries or where there is a complex web of interconnected rules. Only incidentally will uniform conflict of law rules be included in the uniform rules created by Unidroit. They are primarily concerned with substantive law rules. New technologies and business practices are typically the driving forces behind the demand for harmonized regulations. States expressly requesting novel approaches or transactions that, by definition, include multiple countries. Before starting the procedure, Unidroit will determine whether nations are willing to accept a change to their municipal law regulations in favor of a new international solution on that matter. Certain regulations are limited to really cross-border scenarios or interactions, whereas others are expanded to encompass just domestic scenarios or interactions. Unidroit's regulations have typically taken the form of international treaties because it is an intergovernmental organization. Once they are put into effect, these take precedence over a state's national legislation automatically. Conventions are required in the following situations: when the scope of regulations impacts both contract parties and third parties, or similar to the law of property, there are conflicts between the public interest and the interests of third parties. Unidroit has recently favored alternatives like the following because nations frequently dither to implement conventions. Model laws, these are to be taken into consideration when writing domestic legislation on the subject covered. General guidelines, these are presented directly to arbitrators, courts, and contracting parties, who are then free to choose whether or not to use them. Legal guides, these are usually on novel business strategies, new transaction forms, or the structure for organizing markets both domestically and globally. Over the years, Unidroit has produced numerous studies and drafts. Numerous of them have led to the creation of international instruments, and its work has also formed the foundation for those that have been accepted under the authority of other already existing international organizations. The UNCITRAL Convention on Contracts for the International Sale of Goods is one such example. With this, we conclude our lecture. It's now time for your assignment. Remember, there's more benefit in doing the assignment to test your understanding of the topic than just listening and reading without practice. Like they say, practice makes it perfect. Your tutor is always going to be on your side 24/7. You should never walk alone. When stuck, please give him a shout. Don't forget to spread the word about your #1 online ACCA school. To those new to Transkyle Business School, please just say hello to Jerry via WhatsApp or voice call on +263 774 596 368. You can also be attended quickly via email on jmutimukulu@gmail.com. Until next time, please take good care of your dear self. Cheers!